Hey Vermont, I am Jill Martin Diaz, pronouns they, them, and I'm the executive director of Vermont Asylum Assistance Project. I hope you're hanging in there. I am recording a VAAP top five for this week being the week of Friday, April 11th, 2025. Vermont Asylum Assistance Project, or VAAP, is a statewide legal services, technical assistance, advocacy, and community education organization. We are staffed by lawyers and legal workers, and we mobilize volunteers and students to help us achieve our mission. Today, I'm going to share information with you that is also available on our growing educational website that's available in multiple languages, vaapvt.org. You can also follow us on socials at VT Asylum. For clarity, this video does not establish an attorney-client relationship or constitute individualized legal advice. It's not a substitute for individualized legal advice. It's just general legal information to share with folks in recognition that there are way more folks needing immigration legal representation than there are lawyers available to help people. The theme for today's top five is myth busting. We're going to clarify what's going on with the parole termination notices that people are getting all over the state. And we're also going to mention the USCIS registration requirement. So point one, losing parole does not mean that you were deported. And it does not mean that you have to self-deport. It does not mean that you have an affirmative burden to show any ICE officer right now proof of having some other status or pursuing another type of status. It simply means that the government is exercising its authority to end parole, which is a temporary form of permission to be present in the US. And that means that the timeline for parolees to seek other forms of status or other forms of immigration protection is now accelerating. So parole is not a status. It is a temporary permission to enter the US and to receive work authorization while you seek other pathways to relief. It is meant to be a bridge between a person's urgent need to enter the US and their ability to identify pathways to immigration status, whether that's temporary or permanent. So parole was always intended and designed in the statute to be something temporary. And parolees were already in the position of needing to either apply for asylum if they have a fear of returning to their country of origin, or to pursue other protections if they wanted to avoid accruing unlawful presence and to maintain work authorization in the United States. A person who does not pursue other status before their parole expires, or in this case is revoked, becomes undocumented, right? That person loses status and then they're undocumented, as many other folks in the United States are. Millions of folks in the United States are. And being undocumented is a ground for removability under the law, which means that if ICE wants to prioritize enforcement of your removability, they could seek you out, they could serve you with a notice to appear in removal proceedings, or they could put you through an accelerated proceeding called expedited removal, depending on your circumstances. No matter what, nothing about being undocumented or losing your parole status or having your parole terminated limits your right to pursue other pathways, other immigration protections. And so what it does mean, though, is that your timeline, that bridge that the parole was offering, is now much shorter. And now there is a date certain. The notices are informing people that by April 24th, people's parole will be terminated. And that is the deadline when people will become undocumented and lose their work authorization. So the way to minimize the risk of ICE prioritizing you for removal proceedings is to pursue any other status available to you immediately. If you don't, I recognize that the law is very complex. There are not enough lawyers to help everyone in need. And so if you do not, you'll simply be in the posture of being undocumented. And then it would be up to the government to prosecute you for removability. And ICE, if you do encounter ICE and you're put into removal proceedings, it's really important to understand that having contact with ICE is not deportation. Being put into removal proceedings is not deportation, and that in deportation proceedings, immigrants have rights. So if a person who is removable under the law, either because they are undocumented or because of a criminal legal history, or in the case of many student visa holders who are being detained in high-profile actions around the country, maybe that there's a reason to believe that they are a national security threat is another ground for removability under immigration law. What that means is ICE can detain you and put you into a proceeding. Every person has a right to express any fear of returning to their country of origin if you have one. And expressing your fear of return pauses the removal proceeding and triggers your right to a fair hearing on the question of asylum, whether you're eligible for and should be granted asylum. So it's important to know that you can express your fear. You have to express it affirmatively, repeat it if you need to, express your fear, and ask for a lawyer. The government does not provide a lawyer for you, but it has to give you an opportunity, a meaningful opportunity to look for counsel. And at Vermont Asylum Assistance Project, we are prioritizing individualized legal service for people who are existing clients or who are in detention. So express any fear of return that you have and ask for a lawyer. And that triggers due process protections and means you cannot legally be deported until you've exhausted those options. While you're in immigration detention, a couple of things might happen that are very scary and harmful, but again, do not amount to deportation. You might be put into a jail facility. You might be relocated to a jail facility outside of Vermont. You might be relocated to a jail facility outside of the Northeast of the United States. The government seems to be putting as many people into detention as possible because detention is awful and it has the authority to do so, so that people will voluntarily sign away their immigration rights and agree to leave. We call that self-deportation. And there are people who might choose to self-deport, and that is your choice. But what I want everyone to understand is that detention is not deportation. You do not have to sign any documents that ICE presents to you. They may try and pressure you to sign documents. You do not have to sign anything, and you can continue to ask for an opportunity to speak with a lawyer. There are lots of ways that the law protects immigrants who are experiencing detention and who are facing removal proceedings. And know that when we lawyers are given the opportunity to help people assert those rights, we are winning. We are bringing people back from detention from other parts of the country. We're bringing people back to their Vermont communities where they can continue to seek asylum defensively in immigration court or to otherwise defend themselves because they're seeking other status. And so the law, it's working when we have the opportunity to use it. The only way that we're given that opportunity to use it is if you don't sign anything that ICE presents to you and if you ask for a lawyer. It may mean that you will spend some time in detention if that is the route that you choose to take. But know that once you're connected with counsel, and nationally lawyers are prioritizing deportation and detention defense, our legal tools are working. And that's point 4. Besides the parole termination notices that people in Vermont are receiving, we also want to start to familiarize people with USCIS implementing an old law that requires people to register their presence. Basically, the law says it's an old time law that says a person could face civil or criminal liabilities for remaining present in the US without registering their presence for people over 14. There are certain classes of immigrants who are considered to already have registered by virtue of applying for other types of benefits, submitting other types of forms, or having in their possession certain kinds of documents or permissions. We will be recording a podcast about this with the Community Asylum Seekers Project, CASP, in Brattleboro, Vermont, and publishing it online on our website. So stay tuned for that. But just to help demystify the registration requirement, it's this affirmative requirement to register, submitting a form online, G325R. The form requests a lot of information about your immediate family, your spouse and children, your employment history, your contact information, your physical address. And for people who have never come to the attention of government before, it presents a risk that you're bringing yourself to the attention of government by complying with the registration requirement. Note that the opposite risk is that if you come into contact with federal law enforcement, you could face civil penalties or criminal charges. Know that there'll be a particularized cost benefit analysis that people in different positions, different postures will want to think about the risks and benefits of registering or not. We'll help you think through those costs and benefits on the podcast we're recording with CASP. But for now, just know that there is this requirement that is launching this week, and the government says that immigrants have 30 days to comply, or would be at risk of civil or criminal penalties if they come to the attention of federal law enforcement and have not complied when they needed to register. Know that overall, all of these changes, the parole terminations, the USCIS registration requirement, the unlawful termination of funding for our unaccompanied children removal defense funding that we lost at VAAP, everything is being challenged in court. There are lawsuits pending, some of which VAAP is cooperating with as expert witness, some of which VAAP is serving as a plaintiff in. We're one of the organizational plaintiffs that's suing the administration. There are lawsuits pending, and we'll be keeping the community updated on information as it's available about what laws are and are not being enjoined by the courts because they are being passed and implemented in unlawful ways. I know it's a confusing time. Thank you so much for your trust and for being part of the VAAP family. We'll be continuing. Oh, it's April 2025. Sorry about the typo. We'll be continuing to share out top fives as our capacity allows. And meanwhile, be sure to subscribe to our newsletter so that you can get any to-the-minute updates from VAAP that we're able to push through to our subscriber base. Thank you so much, and take care of yourselves.